Good afternoon, everybody. We are going to be talking today about the impact of a very recent Supreme Court case, San Francisco. It's actually the county and city of San Francisco versus Sheehan, and the impact on law enforcement officers' use of force. My name is Michael Coviello. I'm the Associate General Counsel for the National Fraternal Order of Police, working in the Labor Services Division. And in that capacity, I am a full-time employee working exclusively for the Fraternal Order of Police and for the benefit of the members, hopefully for the benefit of the members. Nothing contained in this seminar is intended to be legal advice. The seminar is a suggested guide on how to generally prepare for grievances and represent members in the grievance and arbitration processes. Before undertaking any representation, a thorough review of all applicable laws, regulations, policies, contract provisions, and I have a gremlin here. Thorough review of all applicable laws, regulations, policies, contract provisions, and any other relevant authorities should be conducted, including consulting with experts and professionals in the jurisdiction for advice and counsel, including attorneys that are licensed in your jurisdiction. Now, this is not a grievance and arbitration seminar per se, but all of these matters that we're going to discuss today will have an impact on workplace employment issues. So that disclaimer says what it does for that reason. When we're talking about use of force, the standard for how courts are required to evaluate an officer's use of force comes from the United States Supreme Court case of Graham versus, it's not O'Connor, it's Connor. There's a typo there. We missed that somehow in the proofreading. I'm not sure why we keep flipping screens here, but all right. I don't know what's going on here, PJ. Something seems to be awry with the screen advance. Courts must review the use of force by police using what is known as the reasonable officer standard. And in making that standard, or coming up with that standard, the Supreme Court considers, or instructs courts to consider all the facts and circumstances faced by a police officer in making what they described as a split-second decision to use force. PJ, I'm not sure why this is happening. This thing has a mind of its own suddenly. Under all the facts and circumstances in making the split-second decision to use force. In other words, the United States Supreme Court has directed the courts to consider that when officers are in a use of force situation, to take note of and be aware of the moment-to-moment, split-second actions that are required or that take place that affect an officer's judgment, observations, and actions, and determine that under all of those facts and circumstances was the officer's actions objectively reasonable, using the reasonable police officer standard. Not a reasonable person, but a reasonable person in the shoes of a police officer with all the training, experience, and the stress of the event taken into consideration. Under that standard, the officer must be able to articulate the specific facts and circumstances that led to the use of force. Okay, that's going to be frustrating, and I'm going to apologize in advance for why this is happening. I can't explain it. It has nothing to do with what's happening on my end. There's some glitch in the software, so I'll apologize, and hopefully it won't be too frustrating and you can bear with us. When the officer makes this articulation, it must be in the context of federal and state law and the employer's rules. We're going to come back to this because one of the impacts of the Sheehan case is going to be how, going forward, will employers' rules and policies be affected by the Supreme Court's decision in the Sheehan case. Now, the fact that a supervisor directs an officer to use force does not take an unlawful use of force and make it lawful. For example, if a sniper, SWAT, or special response team is given a go or a green light and that was inappropriate or unlawful at the time the order was given, the individual officers using the force have to come to their own conclusion as to the legality of the use of force and whether or not the circumstances render it reasonable. Now, that sounds like an ominous and awesome burden that you're under, and in some cases it is, but one of the things we're going to discuss today is what the margin of error and the right to be wrong that police officers have under these circumstances. Now, as we all know, under these circumstances, critical incidents involve an extreme amount of stress with an extreme amount of information coming at you at an extreme speed. So how do we determine under those circumstances what is reasonable? We go back to a 2001 case that Christina Kroll, also an Associate General Counsel of the National Fraternal Order of Police, brought to our attention in the case of Saucier versus Katz. In this case, the court evaluated, okay, here we go again, the Fourth Amendment of the U.S. Constitution is violated if force used by a law enforcement officer is excessive under the objective reasonableness standard. Nothing new there. And the court further went on to remind us that the question is, would a reasonable officer have used the amount of force used by the subject officer under the totality of the facts and circumstances known to that officer? This is essentially a recitation or a repeat of what was said in Graham. Where this case starts to go into a different analysis is under the qualified immunity principle. Government officials are immune from lawsuits if the actions taken do not violate a clearly established right. And we're going to figure out and find out in the seminar what that actually means. A right is clearly established if the right is sufficiently clear that a reasonable official, and by the way, we say official, the court says official, that also means police officers, would understand that what he or she is doing violates that right. Now, it's important to note that qualified immunity is not a defense as much as it's an immunity from the suit that relieves the official of the burden of litigation. The U.S. Supreme Court has instructed the lower courts to make the evaluation on qualified immunity at the very beginning of the case as soon as possible to avoid unnecessary expense and burden of litigation for government officials who have otherwise acted lawfully. Now, the right that was allegedly violated must be defined at the appropriate level of specificity before a court can determine if it was clearly established. That's a great statement, but what does it really mean? First of all, the right must be statutory or constitutional, and it must be clearly established. In other words, there must be some precedent or guiding rule of law that is well known before qualified immunity can be refused a government official. In other words, qualified immunity protects all but the plainly incompetent or those who knowingly violate the law. And that's a direct quote from the United States Supreme Court. So in other words, if you go out there and you intentionally violate someone's rights and you know you're doing it when you're doing it, you will not be protected by qualified immunity. Now, why are we calling it qualified? Because it has to be an action that was taken in good faith under all the facts and circumstances known to the officer, and the right has to be clearly established. And we're going to see how this works out in some very fact-specific cases in terms of what would be deemed to be clearly established or not.
Mike, may I jump in for a second?
Please.
If you try hitting the S key, that I believe will stop the automated timer.
The S key?
The S key.
When you say S, the letter S or ESC?
The letter S as in Sam.
Okay, I did that. We'll see what happens.
And you have to do it every slide, just as an FYI.
Okay. Well, that didn't work.
I'll keep looking for options.
All right, thank you. Because police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation, the reasonableness of the officer's belief as to the appropriate level of force should be judged from that on-scene perspective. This is the Saucier court relying on the Graham decision for that language. In other words, the court is not backing away from its analysis in Graham. It's constantly reinforcing it. Now, if an officer reasonably but mistakenly believed that a suspect was likely to fight back, for instance, the officer would be justified in using more force than was in fact needed. So in other words, this is a more classic example would be where an officer fires a weapon at someone who's holding a toy gun. The fact remains that the officer was mistaken that the gun was in fact real, but it was a good faith mistake, and the use of deadly force against someone holding a toy would not be deemed excessive under those circumstances if, in fact, reasonable facts or the facts and circumstances would lead any reasonable person to believe that they were being faced with deadly force themselves. Now, there is a further dimension to this. It's one thing to say that the use of force was reasonable under the facts and circumstances, but what are the legal constraints on this particular decision? The concern of the immunity inquiry is to acknowledge that reasonable mistakes can be made as to the legal constraints. So in other words, factually, you're entitled to make a mistake, which could or could not lead to some legal liability at some point in the further analysis. So you can correctly perceive all of the relevant facts, but have mistaken understanding as to whether a particular amount of force is legal in those circumstances. This sounds very confusing. When we get to the facts of Sheehan, it will start to make more sense. If the officer's mistake as to what the law requires is reasonable, the officer is still entitled to the immunity. So as we go through the facts of each case, you'll see how this plays out. Now, what does clearly established mean? To be clearly established, a right must be defined with sufficient specificity to put officers on notice as to what the law requires. When we talk about notice, we are talking about substantive and procedural due process. Notice and opportunity to be heard. In other words, you cannot be held to a legal standard that you're unaware of. You cannot be held responsible for violating a law or a right that, to the point in time to that case, did not really exist or was unclear. One of the classic examples of an unclear right with regard to Fourth Amendment cases would be, for example, threshold cases. Is the person in the house? Are they out of the house? What does the threshold really mean? There is a volume of case law that talks just about threshold entry into a house. That's an example of how there is not a very clearly established right or protection of a citizen against a government action. So that's just one example. And we're going to get to one that's probably much more realistic for folks who are involved in high-speed chases as we go through the slides. The general proposition, for example, that an unreasonable search or seizure violates the Fourth Amendment, is of little help in determining whether the violative nature of the particular conduct is clearly established. What does that mean? In other words, it's not enough to say that the Fourth Amendment says you are prohibited from conducting an unlawful search and seizure. That is not a clearly established right based upon specific facts and circumstances. You have to have both the facts and circumstances, and you have to have the law that establishes a right based on precedent through either a clear statute or a court decision that puts everyone on notice of what is right and what is wrong in a particular circumstance. The Plumhoff case. This is the case that involved a high-speed chase. This is also a U.S. Supreme Court case. After a traffic stop, the driver fled, resulting in a high-speed chase through traffic on highways and surface streets that exceeded 100 miles an hour, caused multiple contacts with citizen vehicles, near pedestrian runovers, as well as coming into contact with police vehicles on several occasions. The chase ended in a lot where the officers were able to box the suspect in, but he still attempted to evade. He was locked. The bumpers were locked between his car and the police car, and the suspect kept trying to accelerate and get out, and so the officers began firing and fired 3 or 4 shots. The suspect was able to get away from the other vehicles and took off, and the officers continued to fire into the suspect's vehicle. The officers fired up to 15 shots, as was determined by the investigation. The vehicle was disabled. The driver and the passenger in the car were killed by a combination of gunshot wounds and injuries sustained when the vehicle crashed. The daughter of the driver filed a lawsuit alleging a violation of the Fourth Amendment, an unlawful search and seizure. When someone is shot and killed, it's considered to be the ultimate seizure for legal purposes. The suit alleged that the force used by police was excessive because it was not necessary to fire into the vehicle, and the number of shots fired was unnecessarily high. The court rejected the claim that shooting to terminate the pursuit was excessive because of the threat the suspect posed to innocent drivers and pedestrians as well as the officers. So out of hand, the court rejected that the initial shooting into the vehicle as well as the subsequent shooting into the vehicle was unnecessary. So the court was left with regarding the 15 shots. Regarding the 15 shots, the court stated that it stands to reason that if police officers are justified in firing at a suspect in order to end a severe threat to public safety, the officers need not stop shooting until the threat has ended. The court noted that all the shots were fired in a 10-second time span, and that became crucial. The court evaluated the suspect's actions throughout the entire pursuit, during the initial stop, and the attempt to flee, and compressed all of that action based upon all of the reports and the officer's testimony to a 10-second time span. 15 shots in a 10-second time span was not considered excessive in this particular case based upon the court's findings. If that's the case, then there can't be a violation of a clearly established right. Now, an analysis of qualified immunity was not necessary. Once you have determined that there is not a violation of law, the analysis of qualified immunity is not necessary, and the court said so, but decided to do so anyway, again to instruct the lower courts about how these cases are supposed to be handled. The court stated, "We have repeatedly told courts not to define clearly established law at a high level of generality." In other words, it is not enough to say shooting and killing someone is a violation of the Fourth Amendment. There has to be a greater level of specificity in precedent and guiding law to put officers on notice of what it is that they are expected to do and to adhere to when conducting their jobs. In other words, existing precedent must have placed a statutory or constitutional question confronted by the official beyond debate. In other words, there can be no question that what the officer is doing is illegal before qualified immunity can be withheld. The court relied on previous shooting into fleeing car cases and stated that such cases are fact-specific and have to be evaluated based upon those specific facts. In other words, it's not enough to say you can't just shoot into a moving vehicle as a matter of law. The court refused to apply that standard and said that there cannot be a clearly established right in a case or type of case that requires a factual analysis based upon each individual case-by-case basis. So in other words, if you have a factual scenario or the type of case that the courts have said the only way we can resolve this is on a case-by-case basis, qualified immunity will most likely attach because you cannot establish a single rule of law that establishes to that attaches to that type of case when the fact-specific nature of those types of cases has to be evaluated each time one of those cases comes up. Now, the Sheehan case. Sheehan was living in a group home because she had schizophrenic mental disorder and was suffering from that mental illness. The home was specifically set up for people with mental illnesses, and she had a private room. Her caseworker noticed that she was acting erratically, not taking her medication. She wasn't bathing, she wasn't eating, she wasn't attending therapy sessions, and she was becoming progressively more agitated and disruptive. When the caseworker approached her, she became violent, threatened to kill the caseworker, and claimed that she had a knife. The caseworker did two things. She set up an involuntary commitment at a nearby psychiatric hospital, and she called the San Francisco police. When the police officers arrived, there were two of them, they entered her room, and she approached them with a knife in hand this time, screaming and yelling and threatening to kill them. The police backed out of the room, they called for backup, and they devised a strategy to re-enter the room. Backup was not very far away, and they believed that they could not wait for backup for two reasons. They thought that even though they could hear the sirens coming, that they were still too far away. They were concerned that, here we go again. They were concerned that Sheehan was going to be able to arm herself with additional weapons that might be in the room, that she might be a harm to herself. The caseworker in the application to have Sheehan committed specifically stated that she was a harm to herself or a significant threat to her own safety, although did not mention to others, notwithstanding the fact that she had just threatened 3 people, including 2 police officers, with killing them with a knife. But they were also concerned that she might exit the building via a fire escape or a back window. There was a window in the room. They were uncertain as to whether there was a fire escape, but knowing that buildings in the San Francisco area had fire escapes, that was a reasonable conclusion that they came to. As a result of all of this, they devised a strategy to re-enter the room. When they re-entered the room, the more senior officer went first to open the door. The second officer entered with pepper spray, which was out, and deployed the pepper spray. They pepper sprayed her to the full discharge of the canister, but it had absolutely no effect on her. She continued to advance, knife in hand, screaming death threats. The officers then shot Sheehan several times. She survived her wounds and eventually sued for violation of the Fourth Amendment and for violating the Americans with Disabilities Act. She claimed that under the Americans with Disabilities Act that the officers knew she was mentally ill, had the opportunity to accommodate her and should have, instead of provoking her violent response by re-entering the room, knowing that that was going to provoke her. She also claimed that the officers violated the Fourth Amendment by entering a private room without a warrant, and that the second entry was specifically unnecessary since the backup was on the way and there were no urgencies or exigencies. The court considered the ADA claim and did the following analysis. The ADA prohibits a qualified individual from being denied benefits, services, programs, or activities of a public entity or be subject to discrimination by any such entity. So in other words, the City of San Francisco, as a government entity, has to provide the same benefits, services, and programs and activities that they would to anybody else or be subject to a claim for discrimination. A follow-up rule under the Code of Federal Regulations, which administers the ADA, says that a public entity may deny benefits or participation to any individual that poses a direct threat to the health or safety of others. The court further went on to evaluate the rules, saying that a direct threat means a significant risk to the health and safety of others that cannot be eliminated by a modification of policies, practices, or proceedings, or by the provision of auxiliary aids and services. And here's where there was a real problem potentially for the two officers and for the San Francisco Police Department. Sheehan argued that under the ADA, she was entitled to have the officers wait outside until qualified authorities with mental health training arrived to mollify her and to bring the matter to a peaceful, nonviolent conclusion. As it turns out, the San Francisco Police Department policy also required that the officers do this. The court agreed that the ADA may specifically require an accommodation, and that failure to do so could be considered a violation. And they said that the statute could apply to an arrest if the failure to arrest an individual with a mental disability in a manner that reasonably accommodates that disability constitutes discrimination. Now think about what this could potentially mean for the future. If the ADA applies to someone who is attempting to commit suicide by cop, or maybe not attempting to commit suicide by cop, but is in such a disturbed state that anytime you try to approach them and bring the situation under control to protect people in the surrounding area, they become extremely explosive or disruptive, that you could be exposing yourself to liability under the ADA. The court hints that that's possible under the statute, that it is possible in the Americans with Disabilities Act that there is potential liability for a police department, perhaps not an individual officer, but for the police department under those circumstances if that leads to harm. Unfortunately, that's as far as the court went. They said it may happen, but then they punted. And they relied on the fact that the parties did not correctly brief the ADA issues, and because there was no precedent to rely on, the court refused to address the issue. The court instead focused on the issue of qualified immunity, even though they did dip back into the ADA analysis, as we'll see. The court ruled that the first entry was not a violation of the Fourth Amendment, that there were sufficient exigent circumstances of an emergency nature with an armed suspect barricaded in a room who had the potential to hurt herself or escape and be a potential threat to the public. In doing so, the court relied on previous precedent that said law enforcement officers may enter a home without a warrant to render emergency assistance to an injured occupant or to protect an occupant from imminent injury. And the court determined that Sheehan was imminently in danger of injuring herself. As to the second entry, the court was equally satisfied with the officer's actions, stating that the two entries were part of a single continuous search and seizure and an ongoing emergency. In other words, the court said this was an exigent circumstance that had not ended. Sheehan was armed, had threatened to kill 3 people, including 2 police officers, and delay would only have made the situation more dangerous for those that were in the building and potentially outside if she had escaped. The court found the officer's actions reasonable. Now, once again, the court, although did not have to, once the Fourth Amendment violation is denied or is rejected, that claim is rejected, there is no requirement to go into a qualified immunity, because qualified immunity only applies if a right has been violated. The court decided to go into the analysis once again anyway, and in doing so, asked the question, did the officers violate a clearly established right when they entered Sheehan's room to force a confrontation instead of accommodating her illness? Now, again, this is where the court went back into the ADA analysis without actually talking about the ADA. The court acknowledged that there is no such clearly established right. There is no precedent in the country that says the ADA or any statute requires that officers provide specific accommodation to someone who is mentally disabled and in a rage and potentially threatening people. An entry that otherwise complies with the Fourth Amendment is not rendered unreasonable because it provokes a violent reaction. This is something that we've been talking about for many years in a different context in our use of force and critical incident seminars. I have made the statement several times that reckless conduct on the part of the officer that places themselves in a dangerous situation that ultimately requires them to use deadly force, while might be reckless and violative of policy, does not violate law. And the court essentially is saying exactly that. An officer acting inappropriately, provoking a violent response from someone that results in a deadly confrontation, unless it's done intentionally to cause that reaction, in other words, intentionally violating someone's rights, it will be considered protected if there was not an otherwise a violation of the Fourth Amendment. And here's where the court gets very strong. Even if the officers misjudged the situation, Sheehan cannot establish a Fourth Amendment violation based merely on bad tactics that result in a deadly confrontation that could have been avoided. In other words, just because they were required to wait outside the room for backup and for a hostage negotiator to arrive in order to bring this thing to a less violent conclusion doesn't mean the Fourth Amendment had been violated. Think about the impact of this statement. The San Francisco Police Department policy required officers in this situation to withdraw, to respect the ill person's comfort zone, as they call it in their policy, and to use hostage negotiators. The officers clearly did not do any of those things. They gave no deference to the policy in rendering their decision in favor, but the court gave no deference to the policy in rendering its decision in favor of the officers. But the court basically said that even if an officer acts contrary to her training, that does not itself negate qualified immunity where it would otherwise be warranted. Rather, so long as a reasonable officer could have believed that this conduct was justified, a plaintiff cannot avoid summary judgment, meaning on a lawsuit on a civil rights case, simply by producing an expert's report that an officer's conduct was reckless, inappropriate, imprudent, or dangerous, or in violation of policy. This is where the Sheehan case is going to have its greatest impact in years to come. The courts are now going to be required, based upon this language, in my view, and I've spoken with a few other FOP attorneys who are intrigued by this as well, the courts are now going to be required to essentially dispense with the notion that policy has somehow has an impact on the Graham versus Connor standard, or the Fourth Amendment reasonableness standard. We have seen over and over and over again where agencies attempt to narrow an officer's discretion through use of force policy that is inconsistent with the United States Supreme Court standard. This, in my view, is the court saying very, very specifically, your policy is irrelevant with regard to the liability of an officer for having made a decision based upon the facts and circumstances of a particular situation once it's been determined that a reasonable officer would have acted the same way. In other words, the objective reasonableness standard is the law. Stop the debate, stop the argument, stop trying to change the law in your policy. Where will this have a greater impact? Certainly in civil cases, criminal cases where officers are prosecuting. Most likely, the administrative aspect of this will take many, many more years to come to full development, but it is imperative that FOP attorneys and representatives argue the case that your policy being inconsistent with law, according to the United States Supreme Court, means that any job action that you take, any action you take against an officer's job or your career for violating your policy cannot stand because your policy is inconsistent with what the law requires and even allows an officer to do under the facts and circumstances of any given case. It is high time that we stop giving deference to police department policy and start arguing the Supreme Court case law as it applies to these civil and criminal cases in these policy in the policy and administrative disciplinary arena. If we don't do that, we are giving management a pass to rewrite the law based upon their agency's prerogative and not what the United States Supreme Court instruction is. Use of force is determined by the reasonableness of an officer's action under the totality of circumstances, including the time span of the event. Qualified immunity must apply unless there is a violation of a clearly established right, meaning precedent. Policy cannot override the standard of reasonableness under the law, and the application of disciplinary proceedings under policies do not comply with the standard is something that we have to take the strongest action on. Do police officers now have a clearly established right? That's the biggest takeaway. Do police officers now have a clearly established right to engage in their profession in the manner in which the United States Supreme Court said they should back in 1989 in the Graham versus Connor, and no longer be subject to these ridiculous questions by politically motivated prosecutors, inappropriately trained chiefs and managers, and the court of public opinion that seeks to find outrage in a circumstance where an officer following the law, training, and everything that goes along with those things and confronts a violent, angry, or even mentally ill suspect who is willing to engage that officer in combat to the death and then have everybody turn around and tell them that the officer did something wrong. I can't wait to hear the questions. But in engaging in this debate, one of the things that I will encourage you to do is consider the words, and this is one of my favorite quotes from Vince Lombardi. I firmly believe that any person's finest hour, the greatest fulfillment of all that he or she holds dear, is the moment when he or she has worked his or her heart out in a good cause and lies exhausted on the field of battle victorious. If you fight this fight, if you make this argument, if you establish this precedent, win or lose, you will have advanced the cause and we will ultimately be victorious. This debate has got to come to a logical conclusion, and it's just not going to happen until we continue or strongly make these arguments in favor of our officers as they go forth and engage in their profession in the manner in which we all expect them to do, and then in hindsight look back and determine whether or not they're good people. This is our contact information. This webinar will be made available on our website. PJ is going to come on the line and give you more information about that. And we will now answer any questions that we'll answer any questions with the time we have left.
Yes, this presentation will be updated. It'll be available if you go to FOP.net, where the link to the webinar is. We'll put a little red dash saying, or red text saying the video and slides will be available at this link. Mike, we have one question. We have two questions so far. Actually, it looks like three now. The first one might need a little bit more clarification, unless you can follow through with it, is how did this call of service originate?
The Sheehan call? It was the social worker. When the social worker was confronted by the angry Sheehan in her room, who threatened to kill him, he's the one who called police.
Next question is, in light of the Ninth Circuit's ruling on applicability of Title II to arrests, what litigation strategies are available to municipalities? Would the Supreme Court's qualified immunity analysis apply to excessive force claims under the ADA?
This was a question the court refused to answer. At this point, the best we can say is we don't know. But the qualified immunity aspect of excessive use of force, or let's just call it use of force, will always be part of the analysis. And so any attempt to say that a person's rights under the ADA have been violated would first, have to be clearly established, and you have to apply the specific facts and circumstances. The fact that you might be mentally disabled or emotionally challenged but posing a violent threat to police officers would not necessarily create a situation under the ADA that would give you the greater right as an individual to protections of the ADA when you're acting out in a manner that puts other people at harm. So in other words, if an officer's actions are still reasonable when faced with the threat that the person who is making the ADA claim or the dependents of someone who's making the ADA claim are engaged in, then the officers will still have that qualified immunity available to them because they are acting under the facts and circumstances in a reasonable manner. If you're faced with someone with a gun, it doesn't matter whether they have schizophrenia or they just hate cops. You're entitled to defend yourself and others if you're in a deadly force situation, and the yardstick is reasonableness on the Graham versus Connor standard, nothing else.
We have kind of a two-part, well, it's two questions that are very similar, so I'll take the more in-depth of the two. Does the FOP have a model policy that could be available with language consistent with this presentation? It may help agencies draft legally sufficient policy and not policy that is very restrictive. The other question was, how do you make the policy?
Here's the model policy. Use of force must be objectively reasonable based upon the Graham versus Connor standard. We get so hung up in writing our policies, and the policies have to be 15 pages so we can protect ourselves from lawyers and liability and everything else. This case makes clear the only standard by which an officer must be judged in a use of force scenario is whether or not the actions under all the facts and circumstances were reasonable. Okay? There's no such thing as reasonable force. It's reasonable decision-making. Was the amount of force used reasonable based upon the officer's decision to use force faced with the facts and circumstances of the officer's case? Now, if somebody wants to take a stab at writing a model policy that says all that, hey, I'll be happy to participate, but we have a model policy. It's called the United States Supreme Court Graham versus Connor.
And then we have another question. Does this principle apply only to use of force issues? What about policies regarding driving, cell phone use, etc.?
Any use of force has to be reasonable. Now, the decision has to be viewed from the standpoint of an objectively reasonable officer in the same circumstances. Fourth Amendment also has a reasonableness standard. The standards that apply based upon Supreme Court and lower court precedent in interpreting the laws that we all have to live by and that you are required to enforce. The reasonableness standard under the Fourth Amendment is not necessarily the same standard that's used for use of force. All right? The totality of the facts and circumstances for the entry of an officer into a home to determine whether or not there are exits and circumstances might be viewed under a different prism than the use of force, but independently, because that's what was done in the Sheehan case. The first question the court addressed was there a Fourth Amendment violation in the entry into the room based upon the totality of the facts and circumstances faced by the officers? Was the entry into the room reasonable under the facts and circumstances known to the officers in light of the policy that said they should wait outside? The court said yes. The second entry, yes. The use of force when faced with a violent a suspect coming at them with a knife who was not deterred by chemical spray was deemed to be reasonable. It was two separate analyses.
We have, well, several questions coming up. I'm going to kind of split this one. Is there more of a trend to rely on objectiveness, reasonableness, than on use of force continuums? How does the impact of use of force continuums and departments that continue to implement continuums in their policies?
It goes back to what I said earlier. When you want to talk about trends, I don't know what the trends are. I know that use of force continuums go in and out of fashion. I know that there are, on the management side, there are lawyers who I'm very friendly with, who I talk to, who look at use of force continua, whether it be the wagon wheel, the ladder. Some of them have said it should be none of those things. It should be an elevator as you go to the top, and there should not be one particular floor that you get off on. It should be basically a reaction to the force you're presented with. All of that stuff to me is mind-numbing irrelevance. You are judged under the Supreme Court standard based upon whether or not your actions at the time you used the force and the force used was reasonable under the circumstances. Period. That's it. We could talk about use of force continua all day. All that is a creation of lawyers to try and avoid litigation and minimize liability. The unfortunate aspect of that is the analysis gets caught up in, I should have done this first, you should have done that first, you should have waited to elevate. Nonsense. Was what was done at the time it was done reasonable under the facts and circumstances, meaning would a reasonable officer in the same set of facts and circumstances acted the same way? That's it. We could talk about use of force continuum all day long. It doesn't answer the question, and it will never answer the question. It's just a way for departments and agencies that certify departments to feel like they're doing a good job. And I'm sorry, but and I may be a cynic, and it may be what people don't want to hear, but the use of force continuum is a joke. It doesn't answer the question, and it doesn't apply the law correctly.
The next question is, how will this decision impact the decision in Bryan v. McPherson?
I have no idea.
Okay.
If someone wants to tell me what the facts of that case were, I have no idea.
Okay. There's a couple specific questions regarding like the Cleveland, Ohio shooting and the actions in New Jersey, which are similar in departmental policies. Do we want to get into those specific questions, Mike?
I'm not well versed enough in the facts of those particular cases to say one way or the other whether this case will have an impact on those investigations or those cases. Suffice it to say that if the prosecuting authorities in those jurisdictions apply the correct law and evaluate the case the way they're supposed to, the determination of whether or not the officers acted correctly under the law is all that matters. Not whether the problem we have here, is that so many of these shootings are high profile. They become politicized, and then when the law is applied, whether it be in the grand jury process or in the investigatory process, then everybody gets angry because the law requires when an officer has acted correctly under the law that they be exonerated. People don't want to hear that. To change that dialogue, people need to understand what the law is. It's not enough to say that my son was a wonderful child and a pillar of the community and everything else. Okay, he may have been all those things. Let's take all that as true. The moment he pointed a firearm at a police officer, he became subject to the use of force that was reasonable for having pointed a firearm at a police officer. It's just that simple. It's a very simple calculus that has gotten lost in the politics of these events.
That takes care of most of the questions. There is a clarification on the McPherson.
Okay.
Apparently, it is a taser case out of the Ninth Circuit, which highlighted the level of force for using taser in the Ninth, is the clarification that was provided. I don't know if that helps clarify anything for you as far as providing a comment.
Not really, and the truth is I probably read the case, but I didn't read it in preparation for this. So, look, it doesn't matter whether it's deadly force or non-deadly force. The use of force has to be evaluated based upon the reasonableness standard. If we're talking about the Bart case, which is the one I know was a taser case I know that came out of Oakland, that was a case where somebody got confused with their weapons and actually followed the training in deploying the taser correctly, but had his firearm in his hand instead of his taser. But that case was resolved by, I believe it was resolved by plea. It wasn't resolved by a jury. So I'm at a loss. I would need more help from that. I mean, you could throw case sites at me all day long. I'm not an encyclopedia of case law.
Here's
that
actually
would be Will Aitchison. Will Aitchison could probably answer that question.
Here's one that might be a comment worth. Are you saying that officers have recourse if they receive disciplinary actions by their agency for policy violations if their actions were reasonable?
I think absolutely. I think we are making a grave mistake if we do not challenge those actions. If we do not challenge an officer's discipline, and I know in non-labor states this is very difficult to do, but if we're not challenging these disciplinary decisions when the law says the officer has acted correctly, then we're laying down. And that's not right. Now, sometimes the elements of a particular case or a particular situation in a particular jurisdiction may require you to negotiate something to avoid the stress and the burden and the ultimate scenario where you might not have a remedy because you don't have a good collective bargaining law, or you don't have sufficient protections under law in your state, that sometimes those decisions are made for strategy purposes, and I understand that. My point, though, is that where someone has acted correctly under the law, but the policy is inconsistent with the law, then we need to be challenging the policy. And the best way to challenge those policies is to do it preemptively, to do it ahead of time, and not wait for an officer and an officer's family to be on the horns of management's disciplinary intent before we do something. I would hope that anybody who hears this or reads the Sheehan case or any of the cases in that line of decisions from the U.S. Supreme Court would go back and review the policies in their departments and say, this use of force policy is inconsistent with the law and it needs to change. And if we can't change it by having a conversation, then it may be time to start getting the lawyers involved, rather than wait for somebody to have their financial and mental and emotional well-being be thrust onto a shelf by management because they're more concerned about the perception of liability than what the law actually requires. That's what I'm saying.
We have no new questions, just some clarifications on that McPherson case, which we talked about.
Oh, so someone's just not going to let that go.
Well, there's actually about 3 people providing information. It's a
okay,
taser. Okay, I will see if I can put it into cogent order. It dealt with the use of force taser.
If I have the facts.
Yeah.
By the way, the Ninth Circuit consistently gets it wrong. And most of those statements, I edited them out a little bit in the presentation. Most of those statements about repeatedly telling the lower courts to follow the law were directed at the Ninth Circuit. And the Sheehan case comes out of the Ninth Circuit. The Ninth Circuit consistently misapplies qualified immunity law according to the United States Supreme Court.
The clarification so far that we have is it dealt with use of taser during a traffic stop for no seatbelt And it is similar to the Sheehan in the same sense of using force against a mentally ill person. But that's about the extent of the information that's been updated.
Well, I don't know what the status of the case is, if it's been decided, if it's final, if it's going up for review. I don't know. But use of force is determined on the facts of each specific case and whether or not the use of force was reasonable. Don't get confused here that the fact that somebody happened to be mentally ill would somehow remove qualified immunity from an officer. I don't believe the Supreme Court's saying that. What they're saying is, until there's a clearly established right that says mentally ill people have to be treated differently when they point a firearm at a police officer, then they don't have to be treated any differently than anyone else who would do it. People who are acting violently towards police get treated a certain way. And I think that's pretty clear. To treat someone any differently just because they happen to be suffering from a mental illness would fall on a couple of specific facts. Number one, do the officers know that somebody is acting out because they're mentally ill and they've had contact with them in the past? Number two, is there a way to avoid a confrontation because the individual is not posing a harm to themselves and is not an imminent threat to anyone else? Number three, is there some way to accommodate the person until a better solution can be resolved that doesn't put people in imminent harm? Think about it in the context of someone sitting on a park bench screaming at themselves. The police decide to show up, or the police show up and decide that they're going to bring their screaming to a stop by tasing the person. I don't think that works. I really don't. Until someone is posing an imminent threat to the officer or somebody else, use of force is not going to be deemed reasonable, especially since there may be, at some point, a way to bring this person to a calmer state and resolve the situation. Now, we all know that police officers don't have the luxury of walking away from a disturbance. That's what the job requires. You're supposed to be there and to resolve the disturbance. Now, does resolve the disturbance mean you have to go hands-on and put the person in handcuffs and take them away? Perhaps not. One of the things that I think we're all aware of is that departments are really struggling with dealing with the mentally ill when government funding was limited or cut off and caused the mentally ill to be discharged from state hospitals and state facilities and put them out on the streets. The vast majority of homeless people in this country are suffering from some form of mental illness if you read the statistics. So what's the answer? The law doesn't have one right now. But just because someone's acting out doesn't mean that force is necessary. If somebody is acting out and they are not posing an imminent threat to anyone else, then use of force would not be appropriate. Now, in the case of someone sitting in a car who's acting out and could potentially drive away and run somebody over, that's what the Sheehan case looked at. I'm sorry, not the Sheehan case. It was the case before that, the Plumhoff case. This guy wasn't mentally ill, but he clearly wasn't going to stop running from police and had demonstrated his absolute disregard for the safety of others by coming into contact with other vehicles and potentially running over pedestrians. It was deemed that the potential threat that that person continued to pose made it reasonable for the officers to fire at him and eventually kill him. That doesn't necessarily translate into every mental illness situation. There are people that are trained to deal with and have a personality and disposition to deal with people who are acting out without it provoking a violent response. The difference in the Sheehan case is this woman was armed, she had the potential to escape, she was a threat to other people, and she had already threatened people and came at the officers with a knife. They used other resources at their disposal, such as the pepper spray. Had they waited for the hostage negotiators and the trained mental health professionals to show up and deal with the situation, would everything have gone fine? Probably. Who knows? We'll never know. But they made a determination that based upon her ability to escape or further harm herself or hurt herself, that was not a viable option, and the court happened to agree in that particular case. I hope that answers the McPherson question, and I'm not trying to be flippant about it. These cases are very fact-specific, and the Ninth Circuit tends to get them all wrong.
The response is you covered it, Mike.
Okay, good. I'm glad. I'm happy we were able to work through that.
There's another one. I'll cut to the question. Do you foresee the objectively reasonable standard that was clearly established in Graham versus Connor being changed by future Supreme Court decisions?
No. No, the court has repeatedly reinforced it. In fact, if I ever see it changing, it would be to more thoroughly emphasize an officer's subjective view of his or her personal circumstances in the course of an event that he or she is involved in. In other words, if you really look at the Graham versus Connor standard, it's not a completely objective standard. When you consider that the court talks about all of the facts and circumstances known to that officer and what that officer did, would any other officer act in the same way? So there's sort of a subjective, objective test. So if it's going to change at all, I would see the subjective aspect of it being augmented, being made more prominent, because you cannot have an objective officer standard without a thorough consideration of what that particular officer was experiencing at the time of the use of force. So if it changes at all, I think it becomes more favorable to law enforcement, not less so.
Then that is the extent of the questions at the moment. Do you want to wrap it up, Mike?
Thank you, everybody, for participating. Thank you for being patient with us as we struggled with our technical glitches. I apologize again for that. I hope this was of some value to you. And if you have any further questions, don't hesitate to send them in, and we'll address them. I've had some very good conversations with some of the attorneys who were anticipating this seminar. I hope we didn't disappoint. And I'm always willing to talk about strategy in any particular case going forward to see just how exactly these are going to flesh out. The most important thing is we have to always fight the fight and make the arguments that make the most sense. And I think the Supreme Court has given us the opportunity to do this. I think we now have some very strong precedent to attack some of these more ridiculous policies. And I just want to say to those folks out there that are fighting the fight, keep up the fight. Call us when you need us. That's what we do. And thank you for all the good work you do. For those men and women who are paying listen or are still out there on the street, please be safe, and thank you for your service. And we look forward to seeing you all again soon.